Okay. So, welcome everybody to our January 2025 Fiduciary Education Forum presentation. Um, this is Todd Wohl. I'm honored to start out the new year with our presentation this year, just to kind of give those viewers a little background on our Fiduciary Education Forum. Their website is the fiduciaryforum.com. It's fiduciaryforum.com. And both Braun International and Premier Estates, our companies started what we like to call the Fiduciary Forum, FEF, about 2.5 years ago, purely for the education for people in our related industries on topics that are relevant, prescient, and urgent, so that affect their day-to-day business. And we've been very fortunate to have great speakers who take their time out to prepare and make these presentations. This presentation, like most of ours, will be recorded and available on the fiduciaryforum.com website, as well as the presentation itself. And so you can always go back there as a in the library, as we like to call it, and review, watch and the video and review the information that we provide in the presentations. For those of you who don't know me, I'm one of the partners at Braun International and Premier Estates. We work throughout in the fiduciary world, throughout the U.S., Caribbean, and Mexico, providing appraisal services, brokerage and auction services. We provide a capital and lending for fiduciaries and trustees, and a whole host of related services through our different companies and platforms. And today I'm very fortunate to have Yulissa Zulaica, who's one of the founding partners of JKZ LLP in the Bay Area, speak today on foreign assets, taxes, and beneficiaries. Oh my, what fiduciaries should know and be aware of. So with that, Yulissa, why don't you introduce yourself and your firm, and we'll get started.
All right. Thanks, Todd, for the good introduction. And the oh my is supposed to be a little bit more enthusiastic, even though we're going to talk about taxes, but it's things we're all interested
Oh my.
in. Oh, there we go. There we go. We got it. See?
There we go.
We got to make it fun, right?
Yep.
All right. Well, thanks for having me. It's a pleasure always to work with Todd, and I'm happy to answer questions along the way. If you can put them in the chat, if we have that function available, or at the end if we're running out of time, we'll see. But my goal today is really, as Todd mentioned, I'm a trust and estate practitioner. I speak Spanish and, fluently in a couple other languages conversationally, and fell into on the estate planning side and administration. And I have a big tax background on the international component, and that's a big part of my practice. And so one of the things that I would say is my goal today for you all is, if the bulk of the people here are fiduciaries, I think that we have a much more mobile society and clients and estates that we're working in. And these issues about whether it's a multi-state or international client are coming up more and more again. And the goal is, yes, I'm going to give you a lot of rules and lots of facts, and mainly for you to be aware of and have a cheat sheet. And, you don't have to be an expert in all of this, but it's just so you know that there's a little bit extra care when you're dealing with somebody who's not a citizen, who has a vacation home in another country, who is a US citizen but's lived abroad for 15 years, et cetera, et cetera. So in your roles, I would assume this comes up a lot when you're working on someone's estate who's incapacitated, right, during their lifetime, and the obligations that you as a fiduciary would have. And also the liability. And then and then after death, when someone passes away, how does that liability follow you if it does at all? And what do I need to know as a fiduciary? So that's kind of my goal for you today. And then we'll talk about some of the terms more specifically as well. So Todd, next page.
Okay, here we go.
So specifically, I think what we'll touch on today is, what's an estate, and what does that look like when we talk about someone who's international? And I think that can mean a lot of different things. Who is a U.S. person and who's a U.S. person we'll see is different for income tax purposes versus estate purposes. And that's an important distinction that we should also be aware of. And what's the difference if I'm not a citizen or a U.S. citizen living here, et cetera? For gift and estate tax purposes as well. The rules are very, very different, and people should be aware of that as well. And domicile, and what is that? And that's really relevant in determining what type of tax can apply when someone makes a gift or passes away. There's also a whole bunch of treatises that we have, and I provide the links in the presentation, which Todd said would be available to you as well, that you can just click on, available through the IRS website. And that can also impact, all the general rules that I'm going to talk about today can sway them, one way or another, depending on what the treaty says. Reporting requirements. So if you're taking over a matter for someone that has a few bank accounts abroad, what does that mean to you? If you're filing the taxes, what do you need to report? What do you need to do differently? And then how do we use estate valuations in some of our reporting and our purposes when we're administering an estate, either during the lifetime or after death. So specifically, we'll go over a lot of that. And again, if you have any questions, feel free to put it in the chat. But next. So when we talk about international estate planning, it means so much for different people and different things for different people, right? So really at a basic level, I'm a US citizen living abroad, okay? We hear the term expat a lot, an expatriate or an expat. And that is actually a legal term for somebody who gives up their citizenship, and or their green card that goes through that formal process. But a U.S. living abroad, even though they're commonly referred to as expat, is just a U.S. citizen living abroad, okay? And that can involve international planning and considerations. A U.S. person living here but has assets abroad. I have my vacation home in Mexico or in Europe, and that can also impact plans and how you administer an estate. Non-residents with U.S. assets. There's a lot of, Todd correctly said, our main office is in San Francisco. We also have an office in San Diego where I split my time and I'm here today, but, we have a lot of non-residents from the Mexican side with assets on the U.S. side. And what do you do with that? And are there differences? And of course there are. So U.S. persons with foreign beneficiaries, or vice versa, foreigners with US beneficiaries, and then dual citizens. So I think when we talk about international planning, one of the things that I learned early on is if you have a US person living abroad, the way that I best explain this to other individuals is the US follows you everywhere, right? I don't care where you live, but all the rules still apply to you. For income taxes, for estate taxes, you still have to report. The rules follow you. So it's super important to understand that other countries or places where you live or where you reside can impact the planning and how you administer an estate along the way. Okay, next. I'll just go through this really quickly and then we can go to the next one. And I touched on it already. So NRAs is a non-resident alien. That's the term of art. It's, that's what's used in the Internal Revenue Code and why I use it as well. But that is different. Somebody who's not a resident alien, they don't live here, and they are not US citizens. A domiciled individual, we'll go over what that means, but that's also different than an NRA and a US citizen. By default, a US citizen is a domiciled individual for estate purposes, but domicile we'll go into is not a black and white rule. And where you have assets matters. And for your purposes is how you report them, how they may be taxed. And if you're administering an estate and your trust says you do X, Y, and Z, but that other country doesn't recognize the trust and has a forced heirship, then we have a different ballgame, right? Then we're looking at, well, we have a conflict of law. How do we resolve it? And we always have to work with local counsel, but that absolutely comes up pretty often in my practice. So next. All right. So again, I'm going to throw some rules out there because I think it's super important for you to understand the difference, and it applies not just on your settler side and what you need to do if you're administering their estate during their lifetime or on death, but also for beneficiaries that may be in these different roles. Okay. And again, the goal is you don't necessarily need to memorize it, but know that there is a difference. It exists, and that you have this little cheat sheet that you can go to when you're talking to your accountants and your attorneys that you work with. So you can figure out, the course of action that you want to do for your client. So a U.S. person, a non-resident, I touched on, is a person who's not a resident or a citizen of the U.S. Okay. But for income tax purposes, a U.S. person is anyone who's a U.S. citizen. I don't care where they live. And if they're a green card holder, or if they satisfy the substantial presence test. And if you just Google substantial presence test, oftentimes it'll say if you're in the US for more than, 50% of the year, 183 days a year, then you're a resident. However, the rule is actually much more nuanced, and you have to look at, a multiple of years and do an average, et cetera. And that can trigger a residency. So if you're taking over someone's estate here and they're on a student visa, or they're only here for work, right? They don't have a green card, they're here on a work visa, but they're incapacitated here, et cetera. Then you need to perhaps determine this and know that there can be different rules. So there are some exceptions, and we never forget the treaties, and there's tiebreaker rules. And the tiebreaker rules usually you look to, okay, well, if they're part-time here, part-time in another country, where are they residents of? And that can create an impact. And all of this will matter because it affects how you report things. Okay, next. All right, so a U.S. person for transfer tax is completely, well, not completely different. For transfer tax purposes, meaning estate, gift, and GST, generation skipping transfer tax, is a U.S. citizen. So that's the same. U.S. citizen, all the rules apply to you no matter what. And here the difference is, it doesn't matter if you're an income tax resident. It's really about if you're domiciled here or not, okay? And domicile means that you have no present intent to leave. And it looks at your intent now, and it's shown by facts and circumstances. One big mistake that I still see is that people assume if you have a green card, that then, all the transfer tax, the 14 million that you can give away applies. That is not correct. Okay. Having a green card is a factor, an important factor to help you determine if somebody is domiciled here, but it's not the only one. And there's a slew of cases that talk about, what did they put in their visa? How long have they been in the US? How long have they been out of the US? Do they have ties? How often do they visit their home country or their other country, et cetera? So the point is that, just because you have a green card doesn't mean you're domiciled, and we'll see why all of this matters shortly. Next. Okay, so I mentioned this briefly already. A U.S. person for income taxes purposes does not necessarily mean you're a U.S. person for transfer tax purposes. Okay, so that's something you should be aware of. And it's a subjective test, and the green card is a strong factor, but not definitive. And that's something that I hear people get wrong, frankly, all the time. So that's important to distinguish as well. Next. All right, so again, why does this all matter? So let's look at the transfer taxes. So if I'm a non-resident versus a citizen and domiciliary, so here's where it matters. So you inherit an estate. I mean, in San Diego, this happens all the time. We have practitioners that say that they do international planning. They set up a revocable trust for the $1 million home that's purchased in Coronado for a non-resident, and then they die. And then we have an estate tax. Okay. Then the amount that you can transfer on death for a non-resident is $60,000. Okay. For a US citizen or a person who is domiciled, again, the key word there is domiciled. If they're here with a present intent to stay here, is almost 14 million this year, right? So that's a huge difference. Okay. And a non-resident is also only taxed for estate tax purposes in the US on its US situs assets. Okay. So what assets are actually here? That's the only thing that gets taxed. So anything outside of the country would not. On the citizen or domiciliary, you're taxed on your worldwide assets. Again, I don't care where you live. If you're a US citizen and if you have a home in France and another in Mexico, those are considered part of your taxable estate. Okay. Gift tax exemption. There is none for non-residents. For citizens, it's under that 13.99. I'm just going to say 14 million because that's easier, but it's still that 14 million that would apply, and you can't double dip. I'm sure you know that, but just to be clear, it's 14 million combined between what you can give away during life, your gift tax exemption, and the estate exemption. And then there's an additional generation skipping tax exemption of 14 million. Now, one of the benefits from non-residents, and I think this is where if you're a fiduciary, again, it's not your job necessarily, but if you're working with a client who's living and with an attorney, and part of at least having some knowledge in this area, if you know that the person that you're representing or serving as their agent or medical directive or trustee, that they're non-residents with US beneficiaries, if they have assets abroad, guess what? None of those are subject to GST. So we can create on the planning side some really good plans that say, okay, don't give us an estate tax problem and bring the assets here, put it in a bucket, because they're not subject to GST at all if they're not here and they're a non-resident. So there's a lot of planning opportunities. I think that's the takeaway, as well as risks, right? If you're a non-resident as well, and the location of the assets matter more, or just matter. Annual exclusions allowed, but no gift splitting. Gift splitting is allowed with spouses. And the other thing to be mindful of that I still see missed a lot is, I'm married. If my spouse is a non-US citizen, that 14 million that I can give away does not apply to a non-citizen spouse. The annual exclusion is 190,000. Anything over that would eat away at that 14 million. Unless we put it in a certain type of trust. But that's also something to be aware if we have non-citizen spouses. Okay, next. So marital deductions not available to a non-citizen spouse. The non-citizen spouse can give to the US, but we don't have that marital deduction. So again, you have to transfer via a QDOT. It's a qualified domestic trust. And depending on the value, you have to have US trustees, and we'll talk about that a little bit more. And then the marital deduction here is available if you're both citizens on the spouses are both citizens, and it doesn't matter how much money you have, if it's 5 million or 100 million, you can give it all to the surviving US citizen spouse and pay zero tax at the first death. So that's another important distinguishing factor, I think. Next. So what's a QDOT? So one of the things that I think people don't realize is QDOTs, if it's not in the estate plan, believe it or not, it can be established after the fact, after death. So if somebody missed it, or if it wasn't planned for, et cetera, you can set up a QDOT post-mortem and still get the marital deduction. But a qualified domestic trust is, it's in the IRS regulations, and it has certain requirements that in essence make sure, I would say, that it makes sure that the assets are maintained here, right? So if we're going to defer the tax on the first death, the IRS says fine, but because you don't necessarily have those ties that a U.S. citizen has as a non-resident or as a non-citizen surviving spouse, we want to make sure that money stays in a domestic trust just in case you leave, right? So that all income has to be paid out, same with your marital trust. Any distributions of principal are subject to estate tax, and you're required to have a U.S. trustee, and you need to have a bank if it's more than $2 million. So it's just strict in terms of what it's required, what it requires. And I'd say mainly to ensure that the trust stays here. And you can also terminate a Q dot if the survivor then becomes a U.S. citizen. So I've had that happen too, right? So I was non-resident surviving or non-citizen surviving spouse, and then I do end up getting my citizenship. You can terminate the Q dot as well at that point, and often they'll have provisions to make sure that that's an option of distributing in that case. Todd, next, thanks. Foreign trust. So the reason why I have this here, and I don't know if a lot of your clients will be establishing foreign trust out, they're actively setting up a trust in the BVI or another jurisdiction, etc. But a foreign trust is this: if they fail to satisfy the court test and the control test. The control test is kind of easy. It's, do I have a U.S. person that's in control of all substantial trust decisions? Yes or no? If you do, then you satisfy the control test, and that's a U.S. citizen. If I'm trustee and I have complete discretion, I satisfy that. I think where it gets a little murky, and I will tell you that different attorneys will disagree on this point. And I'll tell you my approach, and my conservative approach is that if a U.S. citizen moves abroad, let's say in California, a court in California has jurisdiction over that trust if the trustee has its principal place of administration here, okay? If I as trustee move away and I'm now in, I don't know, living in France, does the court here have jurisdiction? Where does the court have jurisdiction? Okay. And I can tell you, because I've been on the opposite side arguing that it does, that I've had courts try to kick me out. I've argued my way back in, but I don't necessarily think that I've been completely right, because there is a concern about jurisdiction there, right? Under California law, you have to have a principal place of administration, and that's where you do your day-to-day activity. So if I'm not here, or if you're trustee and you move, or you're temporarily someplace else, even if we can do everything remotely now, what does that mean? And if we have a foreign trust, that has reporting obligations that we'll see there. The other reason why I like to include this slide is also because when we think of a foreign trust, it can be inclusive of things that we don't think of are foreign trusts, like a Panamanian foundation or certain businesses that are structured more akin to trusts and not businesses. So you just have to be mindful that when we're also dealing with specific assets abroad, we should understand and distinguish is it really a corporation or a foundation, or is it more akin to a trust? And sometimes you have no idea, or you're not sure. So you just want to make sure you cover the bases and say, okay, I'm going to report them as both to make sure the onerous penalties will not be applied, right? So that's another thing just to be mindful of. And on the disagreement part that I'll tell you is some practitioners will say that because you're a U.S. citizen at the federal level, that the U.S. has jurisdiction over you. I don't want to be the test case on that. And I think on the conservative note, you can register trusts in like Texas, for example, and that would qualify to have to satisfy the court trust potentially. So there's ways around it. And I think, on the conservative side, I would plan for that and keep an eye out for that. Next slide. Actually, go back. I'll tell a quick story about this, actually. So I had some clients, and I think I can say this because most of it is all public record. Husband, wife in Australia. Wife, U.S. citizen, husband, non-resident alien. They'd been living out in Australia, I don't know, 15, 20 years. I can't remember at this point. And they had multiple pieces of property in California worth several $1,000,000. And your estate planner created a trust. Not me, but they created just your basic revocable trust for, husband, wife, and they did put in a Q dot. So they recognized husband was a non-citizen, transferred the real estate in California into that trust, and then life went on, right? Sounds normal. That's what your foundational estate planning is. Then they came to me. I think they probably regretted that. And I said, well, wait a minute. He's a non-resident. Neither of you live here. it doesn't even satisfy the control test because the trust requires consent by both of you to revoke, to amend, to transfer assets, to make decisions substantial related to the trust. Issue number one. Issue number two is, if you're not here and the principal place of administration isn't here, how do I have jurisdiction? Okay. And the reason why they came to me was they wanted to make some changes, but along the way, they got audited in Australia. And the Australian government said, well, wait a minute. When you created this trust, we don't recognize it as a revocable trust. It's an entity. So when you transferred your $6-7 million worth of properties, that was a income tax event, and you owe me all this capital gain. So what do? I can't revoke it because then that's another, capital gain triggering event on the Australian side. So we went to court. And the judge did try to kick us out and say there's no jurisdiction. And, I argued around that under civil code and in rem because we had real estate here. They listened. Probate is a court of equity. I think that's something we have going for us. And I asked that the judge void the trust ab initio, like going back as if it was originally never existed. Let's pretend it just didn't even exist. And the judge did look at me like a crazy lady and say, why don't you just revoke it? And so we had to explain and go through that process that would be a triggering event in Australia. And they almost did not grant our petition, but I asked for further briefing. And, again, because probate is a court of equity, I think you can sometimes get away with a little bit more. And if the judges are willing to listen, and we got that court order, in essence, voiding the trust, since day one, over 10 years ago, and then getting that court order validated in Australia. The point of that story is, even though certain things may seem simple, there's real estate, you do a revocable trust, what's the big deal? It can have big impact, right? So just keep that in mind, and that you should be aware of that. Or if you're the person that they call and say, I need help administering this trust because I am now in another country, well, are they reporting correctly? And did they even report the foreign trust here in the US? And do you want to get in the middle of this if you know things aren't, the way they should be? Because at the end of the day, liability could be personal to you. So again, just, as a heads up. Next. And do we have any questions? I don't think I have access to.
Nothing yet.
Nothing yet. Okay. All right, so what's in the gross estate of an NRA? So again, it's a little bit different. Real estate, interest in U.S. assets, right? Corporation, partnership, investments that you may have here. So those are all included. There are some minor exceptions, and also that you can, from a planning side, can serve as a planning opportunity. So let's say I do inherit that client who bought that home in Coronado, and that's their vacation home, and they're an NRA, and there's not much I can do to fix it at this point. So let's get life insurance, easy fix, and have that pay the estate tax because that's not included in a non-residence estate for U.S. tax purposes. So there's ways to address it too, but there is a difference, again, only what's situated here, and that's it for estate tax purposes, for an NRA. Next. What's even more interesting, let's say, is that certain things, i.e. stock, let's say, or your investments or treasury bonds that you have in an investment account that are definitely subject to estate tax here, are not necessarily subject to a gift tax. So if you inherit a trust administration from an NRA that has substantial assets here, and you say, we have way too much money, there's estate tax exposure galore because we only have that $60,000 exemption, maybe you can do some gifting now, assuming that the power of attorney or the trust allow for that, right? And those gifts that you can give of that, brokerage account wouldn't necessarily be subject to tax, even though it would for estate tax purposes. So there is some flexibility. And while cash in a bank account is not subject to estate tax, if I give a gift of cash here in the US, that can be, or that is subject to gift tax. So something to be mindful of. And same with real estate, subject to gift tax, and there's no exemption. So just be mindful of that. You're paying 40%. One of the big things, and there's cases around this as well, is, often parents from abroad will give children money to buy a home. And let's say they wire the money directly to escrow. That's a problem because for all intents and purposes, IRS is going to say really what you're giving is the real estate. Okay. And then you have to report that as a gift received. And then there's going to be a 40% tax on that. So suggestion is generally, move the money from parent offshore account to kid offshore account, give some time, move it back, make sure that there's no underlying agreement that it's only for the real estate. If you don't buy it, you give it back. You can't have any underlying agreement like that. Or there can be a gift tax on it. Okay. And corporate stock or partnership interest, I have that as a question mark because I think there's some cases in there. And again, I've taken unpopular positions that have not, necessarily been audited, especially on partnership, is if I have a US partnership that owns real estate, so is that subject to give tax or not? And I think that, you can argue one way or another and take different positions, but I think it's not 100% clear. So that's why that's there in kind of a question mark, just something to be aware of. Next. So you'll have these links, but there's treatises with different countries, and all the rules I just gave you can potentially change based on the treaty with that other country. Canada, Australia, the exemptions are higher or the same. So it's just something to point out, that we should be aware of that's there. Okay. Next. All right, so this, if your accountant is not asking you these questions on their intake form, and you're dealing with someone who's not a resident or has some international component, then, maybe work with an accountant who's familiar with international clients, because the reporting obligation can be substantial. The penalties are ownership and the liability can be personal to you. And there's a bunch of cases now happening in recent ones where, the penalties are under scrutiny about whether they're onerous and violate the Constitution because it's cruel and unusual, et cetera. So I think that's still going to be up for debate for a while. And the IRS is going to fight it, but the penalties can be substantial for not reporting. So something to be aware of. So the big one that I see missed a lot is a 3520. So if I receive a gift from my parents who are non-residents, anything over the aggregate of $100,000, or if it's from a corporation a little less, has to be reported. And it's not just receiving cash, but if my parents, corporation own a home here and I stay there for free, that's equivalent potentially to a gift, right? Because I'm not paying rent. So those are just some things to be aware of. And if your client has that vacation home in Costa Rica that they purchased in a corporation because that's what required and have a bank account, you are now subject to these rules. So it's not just for the super large estates. It's for many of our clients. It may have a small vacation home in Mexico or Costa Rica or another country, right? So again, once you take over, you should be aware that in those situations, there may be reporting requirements with the IRS that you have to follow as well. Okay. Next. So there's also a difference on the estate tax return. There's a 706, that's for US persons or US domiciled individuals, and then for non-residents, it's the 706 NA. And I think that over time, one of the questions I had is really, I don't know if you've all heard of transferee liability. And, if the parents failed to report all these things, does that follow to the beneficiaries? And the answer is yes, it can, and it has. And so if you take over an estate that has some of these issues and you identify those issues, and you do nothing about it, there could be liability to you and or the beneficiaries if it's not, cleaned up, right? So if accounts were disclosed, income taxes weren't properly paid, gifts were made, not reported, et cetera, at that point, as a fiduciary, that's your obligation to clean up as well. Okay, next.
I just want to add one thing here, Yulissa, on a
Yep.
case we're working on right now, applicable here with a number of real estate assets. And the real estate assets had to be appraised, but the real estate was, two of the properties were multifamily. uh, the beneficiaries didn't understand what the distribution, what the income was, is um, rents received. Everything was done on the back of a napkin, on the back of a tree leaf. Cash was siphoned. I mean, you know the drill. Um, so we actually were tasked with going through and doing a little bit of forensic work on the rents and understanding what the rents being paid are. And the only way we were able to do that legitimately was to speak to the tenants one by one and get tenants to sign an estoppel because the leases were so far dated. Nobody had the leases, so nobody really knew what was really happening. So the only way for us to do it was to actually get estoppels signed and one by one try to figure out, what the income is and is that income even current? But that's a whole nother story. But yes, sometimes there's quite a bit of legwork that has to be done with real estate or partnership interests in real estate that I'm sure, some of the viewers are aware of but don't really realize how much effort it takes to actually get the information, correct information, and truly know who's paying whom, right? Where are those rents being paid to? And that they be paying to the appropriate people. But anyway, food for thought. I'll move on. Thank you. There you go.
Yeah, I think just to add to that, I think in my experiences, cultural differences are real. And
Yeah.
back of the napkin, handshake deal for a multi-million-dollar transaction is the normal course of business in many places and many families and all that, right? So, number one, try to get people on the same page about why we have to do these things, not complain about the work involved. And then number two is making sure that, again, if you're jumping into a situation where those things happen, because they do, that you're not stuck in the middle of it and are able to sift through whether it's, going back and doing all the digging and getting estoppels and what happened and old records, et cetera. You want to make sure that you do your best there to try to figure out any discrepancies for sure. And I'll just mention also for beneficiaries, this is again, we're talking a lot about administering non-residents and the state differences. There's also withholdings when you have foreign beneficiaries, and that liability can be yours. There's a flat 30% unless a treaty applies. And so oftentimes you'll need a beneficiary to apply for an I-10 and go through a process that you want to start early on. So there's no withholding liability associated with you, or you do the proper withholding. So again, if you have foreign beneficiaries, something to be aware of. Next slide.
Yeah, I mean, I would just add one thing real quick. We're getting into appraisals, but you talk about the backgrounds, the ethnic backgrounds of, different types of people and how they do business and operate. And that's actually a really, really good point. Um, trying to understand where they came from, how they do business, and I don't like to, I'm not saying one type of person or background is better or worse or does business better or worse. They just know what they know and they do it their way. And candidly, even for us, we do put people and what we know of that kind of group of people um, in what's the word, in boxes, in the sense that we understand how their mind works because we've had to negotiate and deal with that type of party. And we don't take it personally. We don't look at it like somebody's trying to hide something or do something in a way that's not, by law. It's just they don't know any better in many cases. And, the father, amassed a whole bunch of property and, he didn't tell the kids anything because that's how his family was. I mean, all these cultural things that affect the decision-making process that affect what we're talking about here right now, appraisals. Um, you just have to work through the process with your client and really do get a good understanding of what is their mindset. I think, Yuli, that's a very good point you make. Um, I
Well, I'm glad you think so. It's on my list of, I think we need to write an article on that because I think it's often ignored. And
Very much so.
it needs to be considered in the relationship in the process and what you do. So
Yeah,
I'm
good
glad.
point.
Yeah. So I did want to talk a little bit about appraisals as well as part of this. Also, we've worked with Todd and his team on a number of occasions, and with property locally and internationally, and that's been a huge help to be able to have that expertise and work with Todd's team in that. And how it comes up, I was using the example earlier is we have an opportunity, you've taken over a case. Parents are still living, we have NRAs, we can make a gift that's not going to be subject to gift tax, but if they die with that asset, it's going to be subject to estate tax. So what do we do, right? And so appraisals, and I think there's a couple of things I just want to point out. When do we need them? Obviously, somebody makes a gift, somebody passes away. What are they giving? What's the current value? We also see them a lot for buyouts and subtrust funding, right? So we need to divide, what's going to go in each subtrust, and we have business buy sells, or one beneficiary wants the business and we want to buy them out. Disagreement among beneficiaries, getting multiple appraisals and trying to get averages. And, that's often what we use. And then the next slide, one of the things that's super important that I also think doesn't get enough attention sometimes is what a qualified appraisal is super specific, right? It's outlined in the regs. It has like 10 prongs in terms of what it requires.
Yep.
And getting a letter from the realtor down the street that gives the opinion of value is not enough. And the biggest issue, if you don't satisfy those requirements, is that your statute of limitations for tax purposes remains open. Okay, so if you file taxes appropriately, you report the gifts, you do the cleanup you have to, but you didn't get the right appraisal, or you didn't work with someone like Todd who's done this before and knows what they require, right? There's a reason why you see all this language in those appraisals and why they're long is because it's required. And if you don't have all that language that's required, then it's arguably not a qualified appraisal, and it's not a qualified appraisal, then the statute of limitations to audit that transaction, that report, that tax return is open. So you lose your ability to kind of manage that window for 3 years. And if you're the one making these reports, then that's very relevant to you and ensuring that you always get qualified appraisal when it's required. Donations to charitable entities, right? So gifts of art and things like that, again, has to be qualified. So this is something that I see messed up quite a bit as well, and why I wanted to spend some time and take advantage of having Todd and having worked with Todd as well. And the next slide is just one of the requirements is adequate disclosure. What are we transferring? When are we transferring it, right? What's the purpose? Those little things are all actually required under the regulation. So be aware of that. I do give, I think, the regulation in there. But yeah, be aware of that.
Let me add a couple things for our listeners. We do a lot of work in Mexico. Mexico has the distinct rules, not only regarding the properties, where they are, what they are, the valuation of them. Um, Transaction, we've sold properties in Mexico, but currently we're working on properties in St. Kitts, in Antigua, um, in St. Martin. And these certain markets do not operate the way the US does, or Canada. And getting information to do the appraisals that isn't a click of a mouse, as I like to say. Um, the property we just got done appraising in St. Kitts, we had to spend literally 4 days speaking to the city and the county, or the city planners and the tax assessors to obtain information, because the information is not public. And there is a tremendous amount of work to try to obtain information about the property, and be able then to opine on it properly. And as Yulissa can rightly probably state as an expert in Mexico. There are a lot of laws and regulations that affect the property when you go to sale. If there's any past due fee, amounts due to any party that worked at the property, um, you can't even close, let's call it escrow, if you want to call it that. You cannot close the transaction until those parties have been paid. There are so many issues when you get outside the U.S. when it comes to valuation that you really have to be very, very careful. And there are a lot of cases that are brought to us that we don't even feel that we're the best qualified for, and try to help the fiduciary or the attorney find somebody that can do that, do the valuation, but do it for the purposes that you're trying to achieve. That's the big thing. Yuli just spoke about it in the last slide. What is the purpose of the valuation and what are you trying to achieve? And no matter what the property or asset is, that's what we need to know, and that's what we try to help obtain. So we'll go on to the next one.
Yeah, and I think I talked about this. Here's the
Yeah.
adequate disclosure requirements and the regulation if you want to look it up, but go ahead. Next.
Yuli, we have one question from a viewer. A question for, well, it's at the end, but we'll just direct answer it right now. The question is, what should a fiduciary think about if they're settling an estate and discover that the beneficiary is either an NRA or a US citizen domiciled outside the US? Is the answer different for probate estates and terminating trusts?
So I think the biggest things there are the withholdings, depending on which country they're in and the jurisdiction, and if they're a US citizen or not. You don't need to do a withholding if they're not a US citizen. If they're a non-resident, then you would. So it's looking at that. And then, with your attorney and accountant does the treaty, do away with the withholding? Is there a lesser withholding, et cetera? And I've had this issue once where we made a preliminary distribution, ensured that it was, a small amount enough that I wasn't concerned about the income tax withholding that we had to do. And then the beneficiary disappeared on us. So they didn't complete their 10. We in essence submitted it, I think, to the IRS, because that was a required withholding, and I was representing the trustee, and the liability there is personal. So either way, we're not giving it to the beneficiary, right? We want to make sure that we do the withholding, and then maybe petition the court for instructions if you get a situation like that where, you can't find them or they are not responsive, right? To make sure that you're off the hook in terms of your obligation, and then ensuring that if any taxes are paid. I think it's also a consideration, maybe if you have a difficult beneficiary, then maybe you have the trust pay the income tax, right? Instead of, flowing the income out to the beneficiary, to ensure that there's no income withholding requirement in that situation. So I think you can approach it a few different ways. And I think if you get anything out of it today I think your question is the question you would ask your attorney and your accountant, and you just have to think of it differently, right? Which you are by asking that question. So there's a few different approaches. And I think one of my takeaways at the end, I always say that having something international makes it a little bit more complicated, or a lot more complicated. And it's not always about the value of the estate, right? It's just about what are the assets, where are they, where do they live, did they do things right or not? And the cleanup is always super more costly to do.
Yes.
But I think that is the question to ask, and depending on, I'll give you the good lawyer answer, right? It depends on the jurisdiction. Is it NRA, US citizen, living abroad, et cetera? The answer would vary, but that's what you would figure out with your attorney and accountant.
Thank you.
Mm-hmm. All right. The other thing that I've seen pop up is, foreign, we have to do a probate because they purchased that property in Puerto Vallarta and it's in their name and there's no will over there. Can we use the California will? You technically can. Many countries, I can't give it a blanket, all countries, but if it's a valid will where you signed it, where you lived, oftentimes you can use it. there's conventions on wills and on trust and which countries recognize, and documents can be apostilled to be used in other countries under the Hague Convention as well. So oftentimes that's what you do. And again, this is not a legal issue, but again, one of the cultural things is the easy example I can give is, the wills in the US, if you've ever seen a will in Australia or the UK, even though we all speak English, completely different, right? And completely different language, completely different legalese, completely different structures, etc. So legally, while my California will could direct the disposition of assets in the UK, let's say, it can be more of a headache. And same thing in Mexico, right? So I have that Puerto Vallarta home, let's say. I have to get it translated. I have to get it apostilled. And then they're trying to interpret it. So there's more cost and administration that maybe we should have just had two wills. So that's on the planning side. But if you only have the will here, you could use it. It's more work, apostilles, etc., most likely. Then we also have conflicts of law. Is there forced heirship, right? So making sure you're always working with local counsel, always hire local attorneys. And if your attorney here isn't working with someone local, that's not a good thing. You should always have someone local. Then, how does the will, how can you apply the will? I've had situations where we had it was a litigation matter. I think I'm known for all the messy cases, right? Whether it's on the planning, the tax, or the admin, and there's litigation. So there was litigation here, and I had a will in Spain and one here, and assets in both countries, and the decedent, a US person, lived in Spain. And the California courts wanted the original will, and they were asking, well, why isn't it lodged? And the way that it worked in Spain, you go through a notary, and they keep the original, right? And what I see a lot is that when they worked with the attorney, that Spanish will said, I revoke all of my testamentary instruments. Well, the litigation was, does that testamentary instrument also revoke the trust that's been around in the US for 15 years that dealt with the US assets, or did it only apply to Spanish assets because there was conflicting language, right? So always super important to work with counsel in both countries on the planning, on the admin, and then we had to get, expert declarations on the Spanish side as to why it couldn't be produced, et cetera. So the rules are just very different, and you have to find strategic ways to work around them sometimes to make everybody happy if you even can. So just something to know. Okay.
Just add one thing, you probably deal with this day in and day out yourself, and are probably a great resource. But when we speak about Mexico and you're talking about transacting real estate, you literally need a real estate attorney in Mexico to assist with the transaction and sale. We've sold properties in many parts of Mexico, and the first thing we want to have is counsel in that local city that knows the rules and regulations for that city. So having local counsel is very important in many facets. Next slide, Yuli.
I don't know if we have enough time for the case studies. Any other questions? And maybe we'll do one. Any other questions? Okay, so I'll just jump right in. So let's say Julie, she's a professor at UC Berkeley, dual French and US citizen. She lives here and she wants to move to France, goes to France, has a few bank accounts, and has a corporation that she owns her rental property. All of her beneficiaries are in France as well. So what happens here? So if you're the administrator, I'm going to change it up a little bit, but let's say you take over while she's alive, she's in France, and I don't want to deal with my US trust. I just want somebody to manage those separately, their rental properties, investments, and that's it. So you take over while she's alive. Well, you under the trust, it may not be a foreign trust because a US person has control. It could be for her. One of the things in France that I've gotten conflicting opinions from French counsel is that, France historically hasn't recognized trust. And I think now they're implementing in the last handful of years, at least recognizing foreign trust and creating obligations on the trustees to report in France, right? Just because you have a beneficiary in France, even if it has nothing to do with anything else French. And I've gotten that even on the revocable trust side, that's what it should be doing. I think probably that's the more conservative approach. But just as an example of how different the rules can be when we're dealing with a foundational revocable trust. Okay, so if you're a trustee, have French beneficiaries, do you need to report in France? Maybe, right? So that's an example. And then if she passes and she has all these assets, can you go to the other slide? In France as well. Well, did she report them? Did she file the appropriate forms? While she was trustee, was it a foreign trust and was it reported that way here in the US? Forget about France. And she's a US citizen, so we have to deal with estate tax. And what I haven't even touched on really, there's also an inheritance and wealth tax in France. So what do we do with that? Are we double paying an estate tax? You can get a credit, and again, treaties can apply. But if there is no treaty, or depending on the rules, sometimes you can be dinged quite a bit if we don't plan for that as well. Okay. Next. The other thing is a reminder, same-sex marriage. It's still not recognized everywhere. And if you're married here and it's not recognized in another country, I actually had a client that died right before it was at this interesting time where they were US citizens but had a vacation home in Costa Rica. And they died, one of the spouses died right after it was legalized in Costa Rica, but before the law was implemented. So there was a little bit of a kind of an unknown, and well, which laws apply? Because if we apply post legalization, then the spouse inherits everything because there was no will. So, and there was, they would inherit, but if it wasn't legal, then they get nothing under Costa Rican law in that situation. So which applies? So we, instead of going straight and doing a probate in Costa Rica, we opened a probate in California to be able to enforce a court order here in that jurisdiction to say that that individual, the surviving spouse, was legally entitled to all the assets in the US and in Costa Rica. So it was a process, right, that we had to go through. But those small facts, sometimes you just don't know what to do, right? And you're sifting through, well, if we approach it this way, X, Y, and Z is going to happen a different way. You just have to be careful and mindful. So something to be aware of. There's also a regulation, an EU regulation that actually I haven't looked at this recently, but that regulation in essence says, you can choose which laws you want to apply. So if I'm domiciled in California, I'm going to choose I want California laws to apply instead of the forced heirship in France. So that's potentially a way to apply, and give to beneficiaries other than those that would inherit under forced heirship. But one of the topics of conversation that I haven't looked at as of late, if I'm honest, is well, the EU regulation says you can pick another country. But in the US, our intestacy rules do not apply by country, it's per state, right? So I don't think there's been a test case yet that for under California purposes, if I elect California, does that apply? And has anybody, said no, California is not a country, so you can't make that election. But just something interesting that I think is there. And I guess that's me. I think we're out of time. That's, me, as Todd said, I'm a trust estates attorney. I focus on a lot of cross-border high net worth, and generally, the messies, I think, is what I've become known for. And trying to put those pieces together, and the firm as a whole, we're, boutique, and that's all we do. Trust and estates, family law, business, all kind of within that private client world. And if we can ever serve as a resource to you, redirect you, etc. I split my time between San Francisco and San Diego, where I grew up. And then we have a small office in Chico. So always happy to serve as a resource, even if you're working with another attorney, and get you to the right person, and collaborate. So thank you for having me, and Todd as well for thinking of us to collaborate with you here. And it's always a pleasure to work with you as well.
Well, thank you, Yulissa. We appreciate you being on, everybody for joining us. Our next presentation will be at the end of February. We have our topic that is being solidified in the next week, so look out for that. And Yulissa's firm is JKZ LLP. And she's being extremely modest as to her and her associates and partners' skill sets, and geographically covers, works in many parts of the state and has a lot of expertise beyond just literally what we're talking about today. But so please, for our viewers, this will be up on the fiduciaryforum.com website as well as the presentation. And if you want to reach out to Yulissa directly, Yulissa, what's your email address?
It's just my first name, Yulissa, at jkzllp.com.
Okay. Well,
Happy to.
everybody, have a good rest of the week, a good month. Be healthy and safe. And we'll look forward to seeing you at the next Fiduciary Education Forum presentation. So thank you all, and we'll look to see you all soon. Thank you
Thanks
very
much.
much. Thank you, Yulissa.
Thank you. Bye.
Appreciate it. Thank you. Thank you all. Bye-bye.